Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this live streaming content, and today will be the day I earn your subscription. So this is a bit of a special video in some ways. This might be the last I'm shooting from this particular apartment. Moving to a different area of town, so, I guess that's interesting. So, yeah. Anyways, we are here to discuss a memo that was filed, amicus, I guess we'll call it, in the ongoing Prince Andrew case. As you will remember, Virginia Giuffre sued Prince Andrew, stating, among other things, that he was part of the scheme of the trafficking with respect to her, that he was involved in that trafficking, and that he would bear some responsibility and liability for that. Okay. So some random guy, because I got as far as pro se, which let me know we were in for a good time. Some random guy has filed a amicus brief, I guess, and I haven't read this yet, but I've been told good things, and so I'm looking forward to covering this. All right, so let's go ahead and get started with this. Excuse me one second. There we go. Correct the margin real fast. Great. Okay. Emergency petition for an evidentiary hearing to review evidence that constitutional and statutorily requires granting a motion to dismiss with prejudice in this case. Brought by Mr. Walter Lee, pro se petitioner. We're in for a good time. Random guy is entering a petition to dismiss in this case. Fun. The petitioner presents evidence that defendant cannot receive a fair trial in the United States of America because the U.S. Supreme Court and lower courts created by Congress do not support the U.S. Constitution as the supreme law of the United States of America. Oh, okay. Okay, just that, I guess. All right. Motive for murder. In Walter Lee versus John Ashcroft, so this is not his first rodeo, it seems, former U.S. District Judge Thomas Jackson, R.I.P., presided over this case where petitioner legally challenged the constitutionality of the ruling of the U.S. Supreme Court in George Bush versus Al Gore. Wow. Wow. The petitioner argued the seriousness of the alleged offenses, warranting the Attorney General present evidence to a grand jury IAW, I have no idea what that means, the applicable and controlling law. The controlling law was decided by the Supreme Court. That's one of the things they do with their time. Judge Jackson issued an order that essentially contained three conflicting rulings. First ruling, the case is frivolous and failed to state a claim. Yeah. Second ruling, the success of plaintiff's claims necessarily requires invalidation of current presidency. Third, the legitimacy of the President of the United States is a moot point. Commentary. Any case that challenges the rulings of the U.S. Supreme Court and prompts a federal judge to rule the success of a case would invalidate the current presidency of the United States can never be considered legally frivolous. Yes. In fact, they almost certainly are always legally frivolous. When you're talking about the current president of the United States, so after like any election challenges after they've been installed, I mean, yeah. Nor does the case fail to state a claim when petitioner has the right to petition the AG and the court to present evidence to the grand jury. No. I mean, I suppose you can petition the AG, but not the court. You can't get a mandamus ordering him. Finally, any case challenging the legitimacy of the POTUS is never a moot point because American people are entitled to a president who is legally and lawfully elected to sit as president of the United States. IAW, which apparently means in accords with the applicable controlling governing provisions in the U.S. Constitution. He was. I mean, for the many, many problems of that, they went through legal processes and legal challenges, which were determined by legal courts, and they made legal rulings in accordance with legal principles, and those were heard by the House and Senate, who ultimately have the ultimate authority on this issue, and they counted the electors from those states, and they installed him, and he was sworn in, and that's the process. So, you know, Donald Trump received his fill of going into court after court after court, legally challenging the legitimacy of the presidency. He wasn't president at the time he was doing that. He was challenging the election results before, as part of the certification process, not after, once he was installed. Totally different. And also, a lot of those were crap. Providing a legal challenge to the legitimacy of the Biden presidency was not ruled to be frivolous or moot by any judge. I'm pretty sure they were. I'm pretty sure that several of them were ruled to be frivolous. I'm pretty confident. Stare decisis, anyone? Stare decisis has nothing to do with this. Those cases turns on the facts of those cases, like all cases do. I mean, the stare decisis refers to particular legal principles, but I don't think any of the cases involving Trump set new legal principles. I think they were all applications of facts to current existing legal principles. So stare decisis isn't really a thing. The petitioner argued the inability of the U.S. Supreme Court to defeat the petitioner's argument statutorily. Wait, what? The petitioner argued the inability of the U.S. Supreme Court to defeat petitioner's argument statutorily. They did do it statutorily. There's nothing unstatutory about what they did. They have the right to review cases or not. Proves the U.S. Supreme Court is guilty of high treason and rebellion, among other things. Okay. The petitioner further argued that commission of high crimes by the U.S. Supreme Court is not only evidence of a commission of impeachable and criminally prosecutable offenses, but that from the offending date of the commission of these high crimes, among other things, the Supreme Court no longer possessed the constitutional statutory authority to exercise sovereign judicial powers of the American people to sit in judgment of cases and controversies. Wow. Now, okay, just by way of note, you can impeach a Supreme Court justice. One Supreme Court justice was impeached. He wasn't convicted, but it did happen once, long ago. And federal judges have been impeached successfully, most often for, monetary issues, fraud and stuff like that. But, it has happened. I mean, a baker's dozen of times or something around that, where a federal judge has been thrown off the bench. It happens sometimes. You can impeach a judge. You really can. So if it's true that the Supreme Court justices have committed high crimes and misdemeanors, you can impeach them. That's an option. I don't think anyone anywhere has suggested that, except you. So, coming up with a ruling that you don't like isn't impeachment worthy. Even though, like, for example, Wickard v. Filburn or Chevron was decided unanimously, and I think unanimously wrong, as much as I might like to, I don't think I can impeach the justices for that. It just was a bad decision. They've made other bad decisions. It happens. And if the fates are kind, maybe these will be overruled someday too. Moment to digress. A few key cases filed prior to Lee versus Ashcroft. Oh, he's giving us a history of himself. How thoughtful. In Walter Lee versus George W. Bush, I challenged all laws signed by the president on the grounds President George Bush lacked the constitutional authority to exercise the executive powers of the American people to sign bill into law. No, he was sworn in. I remember. In Walter Lee versus George Bush, I challenged all nominations made by Bush on the grounds President Bush lacked constitutional authority to exercise executive power to nominate any person. No. No, he was sworn in at the House and Senate, got together, counted the electors. Some objections were made, incidentally, by some Democrats. So, it happens. In Walter Lee versus George Bush, I challenge President Bush's authority to send servicemen and women into war on the grounds Bush is not the possessor of constitutional authority to exercise the executive power of the American people. One wonders why he has such a losing record. It's hard to tell. All the affirmation cases were dismissed with prejudice because the U.S. Supreme could not then, nor can they today, defeat the merits of the argument. They can, they just can't be bothered. The other federal courts took care of that for you in the cases you filed in, and you appealed and lost, and the U.S. Supreme Court can't be bothered to hear your bullshit. Due to the petitioner's ongoing litigation in various federal and state courts and the level of trepidation of the petitioner exhibited by federal and state judges in these courts, I don't think it's trepidation. I just think they think you're an idiot. The petitioner wanted a record. The U.S. Constitution is supported as the supreme law of the United States of America by the judicial branch. The Constitution is, in fact, the supreme law of the United States, which, among other things, sets out three branches of government, one of which is the judicial branch, which, at least according to my reading of Article 3, a point of difference between me and Nick Rekieta, at least according to my reading of Article 3, has the authority to declare laws to be unconstitutional, among other things. So, yeah. This led to Walter Reed versus the United States. He sued the federal court. On the 12th of August of 2002, U.S. Magistrate Judge Stephen Van Camp issued a rule denying the petitioner's motion for appointment of competent legal counsel. That would be hard, because no legal counsel could bring this claim. Deny the petitioner's motion for oral argument, support a petitioner. No. Deny the petitioner's motion for a copy of local rules of the court. No, they're available on the web or anywhere else. No. Deny petitioner's motion to acknowledge the U.S. Supreme Constitution as the supreme law of America. It's like, I just don't want to get into it with you. No. This led to Walter Lee versus Stephen Van Camp, the judge. He's suing the judge. You can't sue the judge. They have absolute immunity for their rulings. On the 6th of September 2002, U.S. District Judge John Sedgwick of the U.S. District Court for District of Alaska responded to my claim seeking $100 million, where I accused federal officials, United States Supreme Court and former U.S. District Judge Mary Magura, currently on the Ninth Circuit, of plotting to kill me because of the merits of my claims. It's a literal murderous conspiracy. Wow. The inability of the U.S. Supreme Court to defeat petitioner's argument proves that any person who petitioned the U.S. Supreme Court for a stay of their execution after the offending date and their petitions was denied, and as a result they were executed, that they were deprived of due process, which includes going before a tribunal with the power to decide the case, their case, which is an act of first-degree premeditated murder. So let me get this straight. You think that because the U.S. Supreme Court refused to grant certiorari, you think that's an admission from them that they can't defeat you on the merits. And therefore, your merits are correct. And therefore, the U.S. Supreme Court is illegitimate, and therefore, every death sentence after that date is necessarily illegitimate. That's a lot of logical steps, man. Now consider the response of the U.S. government after being accused of plotting to commit the capital high crime of first-degree premeditated murder. No. While Mr. Lee's claims of a conspiracy to commit premeditated murder through the ruse of a court order, straying credulity, even if they were true, his claims would not suffice to breach the barrier created by the doctrine of judicial immunity. That bulwark has been erected of necessity to protect an interest more important than redress of any particular case, society's interest in an independent and impartial judicial system. Yeah, you can't sue the judge. It doesn't make any sense. Well, you can't sue them for their official acts. So, The U.S. government does not deny, dispute, or attempt to disprove. They conspire to murder me. They can't be bothered. The U.S. government responds to this by saying it's hard to believe the U.S. government would conspire to murder me. Well, when the petitioner filed this case seeking monetary damages in excess of $20, the petitioner's Fifth and Seventh Amendment rights to due process and equal protection of the laws in a public trial by jury were invoked, thereby proving this defense and other defenses offered by government must be made in a public trial by jury. Only if you have a case. Only if you have a case. Right? The jury, lest I remind you, is the finder of fact. What the jury decides is facts. They decide different people are offering different versions of the facts. And what the jury decides is which version of the facts sounds the most true. That's what they do. Now, what the judge is doing in a motion to dismiss is he is taking the complaint as filed as true. He is assuming every single fact you say is true. So we don't need a jury because we're assuming, for the purposes of the motion to dismiss, every single fact you say is true. So there's nothing for a jury to do because you win all the factual arguments. Then the judge just asks themselves the question, based on those facts, could a jury rule in your favor? No. So you can't get to a jury because there's nothing for a jury to do. He's already assumed all your facts is true and you still can't win. That's the nature of the motion to dismiss. The U.S. government also ruled that a doctrine of man had been created by the federal judiciary to such heights until it is now interpreted as being more important and therefore superior to the U.S. Constitution and our right to petition the government for redress. I don't know what the doctrine of man is, and I'm scared to ask. The petitioner contends that this ruling is sufficiently credible evidence. It's not. To prove that the district court refused to support the supremacy of the United States Constitution, rights, privileges, and immunities therein, is therefore guilty of an act to rebel against the authority. You understand that they are part of the authority, right? In the judicial branch, which is part of the enumerated branches of government, they are part of the authority of the government. You get that, right? Okay. On the 8th of January of 2003, former Chief Judge Mary Schroeder of the Ninth Circuit U.S. Court of Appeals denied petitioner's appeal because the petitioner was too poor to pay the cost to litigate the merits of the appeal and therefore placed on a legal record, knowingly engaged in a criminal conspiracy. Yeah, again, they're going to take a look at it real fast to see if it has any plausibility before they allow you to file in form of papyrus, in the form of a pauper. You can file without paying fees in form papyrus, but they're going to take a quick look at it to see if it has, any merit whatsoever. And if it doesn't, they're going to deny your right to file because it's crap and they can't be bothered. The Ninth Circuit Court of Appeals knowingly engaged in a criminal conspiracy with the district court to rebel against the authority and laws of the United States and to deprive petitioner of his Fifth and Seventh Amendment rights in due process and equal protection. No, you have no case, even assuming all your facts are true, which is the best possible outcome from the jury. They believe every word you say is the best possible outcome. You still lose. There's nothing for a jury to do. This ruling is sufficiently credible evidence to prove the appellate court does not support the supremacy of the U.S. Constitution and our rights therein, and knowingly engage in criminal... Okay. This led to a letter from Chief Justice John Roberts. On the 10th of May, 2007, Chief Justice John Roberts refused to docket my petition for writ of certiorari, and in the process upheld the lower court's ruling that the U.S. Constitution is not supported as the supreme law of the United States by the U.S. government because the U.S. government supports doctrines and precedents as the supreme law of the United States. Well, yeah, to some degree this is true because we work on a common law system. which is also baked in the Constitution, incidentally, because we inherit our legal tradition from England. So yes, precedent, for better or worse, is part of the constitutional system because we work on a common law system. So when they make mistakes, which, they do and have made, and still some are uncorrected, when they make mistakes, that's part of the constitutional interpretation. Because, someone has to decide what it means, right? Someone has to decide what it means. And it seems to my mind, again, going to Article 3, the U.S. Supreme Court and all inferior courts are authorized to hear all cases in law and equity. So, that would necessarily, at least in my mind, include their ability to strike down a regulation in view of a statute, or strike down a statute in view of the Constitution. Because Constitution, remember, is the supreme law of the land. That's what it says, right? That's the nature of it. So if a statute or a regulation conflicts with the Constitution because it has a place of primacy, which it's supposed to have, then what else can you do but say, okay, the statute or regulation is unconstitutional? This law conflicts. The conflicts of law, by the way, is not like an incredibly unknown concept. You can have conflicts of law within the same band. You can have two statutes, for example, that are competing with each other. It happens. It happens. Because the legislature is dumb. Right? So you have statutes that compete with each other. Sometimes the same statute competes with itself, which is at least partially true, for example, in the Obamacare cases with the Affordable Care Act. The Affordable Care Act partially conflicted with itself. So one of the things that they do is they have to say, well, okay, the statute conflicts with itself or it conflicts with other statutes. So what resolution? Which one wins? Which one loses? And so forth and so on. So conflicts of law principles are perfectly well known. And then all I've done is say, well, okay, now it's not statute versus now it's not statute versus statute. Now it's statute versus Constitution. And Constitution has primacy, so Constitution wins. So I think that's what Article 3 says, in my humble opinion. The U.S. Supreme Court in its inferior cases can hear all laws in equity or law, which are all the cases. And necessarily that implies they can rule that something defies the Constitution, at least in my mind. And we're on a precedential system, so that's what I think. Where was I? This letter is sufficiently credible evidence proving the District Court, the Appellate Court, and the U.S. Supreme Court do not support the supremacy of the U.S. Constitution, proving that Prince Andrew cannot receive a fair adjudication of his case in the United States of America, thereby necessitating this court to issue an order to dismiss with prejudice. Wow. Exhibit 6, letter dated to President Bush. Exhibit 7, letter dated to President Obama. No response from Donald Trump or President Joe Biden regarding these issues. No. For the record, IAW, Article 3, Section 1 of the Constitution. Every Article 3 judge must be sitting in good behavior to possess the constitutional authority to exercise the sovereign judicial power of the United States. Correct. And this means the exact same thing it means in the presidential context. Right. Which means that the Congress can impeach them. So, when sitting in good behavior is legally defined as a standard of conduct by which a judge is considered fit to continue their standards of tenure in office, and the standard includes not committing any high crimes and misdemeanors, then you must prove you're not guilty of committing any high crime or misdemeanor. Okay, kids, where did he go fundamentally wrong? Where did he go fundamentally wrong? Then you must prove you are not guilty of committing any high crime or misdemeanor. Where did he go wrong, friends? Federal questions. Oh, he's apparently just going to ask questions now. That's not what a federal question is. That's hilarious, though. So federal courts federal courts can hear two kinds of cases, at least. They can hear diversity cases where one party from one state is suing a party from another state for more than $75,000. They can also hear what's called federal questions, which just means it arises from a federal statute or federal regulation or the federal constitution or some other federal action. It is in the nature of the federal government and their actions or their statutes and their regulations that the case comes to be. That makes it a federal question as opposed to a state question. But he's just going to ask questions, so okay. First federal question to Lewis Kaplan. Do you support the Constitution and all rights, privileges, and immunities therein as the supreme law of the United States? Yeah. He's not going to answer any of these because he can't be bothered, nor does he want to give it any legitimacy. But U.S. District Judge Lewis Kaplan, are you singing good behavior? The U.S. Congress seems to think so. Third federal question. Lewis Kaplan, have you deprived and or aided or abetted the deprivation of a person's life, liberty, or property without due process of law? What do you think I'm doing here? As a judge, what do you think I'm doing? I am due process of law. That's why I'm here. Fourth federal question. Judge Lewis Kaplan, do you recognize Prince Andrew as a full human being and person entitled to due process and equal protection of the law? Sure. Fifth and sixth questions. Judge Kaplan, what does the U.S. Constitution say must happen next when a petitioner's Fifth and Seventh Amendment rights have been invoked, yet the District Court, Appellate Court, and Supreme Court have refused to support the petitioner's right due to due process, equal protection laws, in a public trial by jury, yet these rights are preserved and all the justices on the Supreme Court are sitting on good behavior? There is no remedy. The answer to your question is there is no remedy. You have exhausted all your legal remedies. There is no remedy. You have gotten a final decision from the courts. I suppose your only remedy then is the political. Your only remedy is the political. Convince the United States Congress to impeach and convict the federal judge or judges or the entire Supreme Court. Then with new and improved judges, maybe they will reconsider your case. I mean, that's your only remedy left. You have no legal remedies. You've exhausted them. Yeah. Internal petition to President Joe Biden. What the hell is this? I do solemnly swear or affirm that I'll faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. President Biden, why are we talking to President Biden within the context of within the context of an amicus brief to a court? President Biden, this is your oath of office, yet you repeatedly refuse to support the supremacy of the U.S. Constitution, my civil rights, and the collective civil rights of the American people. This allows precedents to stand that say the government can murder a person for exercising their First Amendment civil rights. What case are you talking about? The government can conspire to deprive a person of their civil rights due to their impoverished status. It's because you're saying nothing that makes any sense. And the government supports doctrines and court precedents as the supreme law of the America instead of the Constitution. Again, this is a little bit, in my mind, baked into Article 3. So I don't agree with that. Now, based on these facts, why would anyone want to vote for you when they already know you have dishonored your pledge to the allegiance of the flag of the United States of America and the republic for which it stands, and disobeyed your publicly sworn office to your God to support the supremacy of the Constitution and our civil rights? That is a perfectly valid question. And that is a political question in the literal sense. Why would the people support him? I don't know. Convince the people at large they should not support him. If the people do not wish to support him and they don't wish to vote for him for another term, then he will lose his position. You have a political remedy. I don't know why the people would vote for him or not. Convince them not to vote for him. You have a political remedy, and then he won't be in office anymore. I mean, that's how that goes. I've exhausted the judicial remedies available to me to obtain due process. You obtained it. And equal protection of laws. You got it. In a public jury trial, there's nothing for a jury to do. Even so, these rights are still just as valid and enforceable today as the day they were invoked. I suppose that's true, but your case still makes no sense. When you swore an oath to take care of the laws are faithfully executed, and my Fifth and Seventh Amendment rights are the supreme law of the United States of America, you must recognize the U.S. government is in default because I cannot obtain due process and equal protection of the laws in a public trial by jury, in the legislative or executive. And these facts dust. And these facts support my petition for you to issue an executive order to award me the $100 million sought in the complaint, and you must convene both houses of Congress. Oh, joy, a federal judge ordering Congress to convene. I don't remember that power. With instructions for the U.S. Supreme Court to appear and give sworn testimony as why they refuse to support the supremacy of the U.S. Constitution and our collective rights, privileges, and immunities. Wow. The inability of the U.S. Supreme Court to defeat my argument, I can defeat your argument without breaking a sweat, is sufficient evidence to prove that they did not possess the constitutional authority to exercise sovereign judicial powers of the American people in Shelby County versus Holder. What? This fact necessitates the House to impeach and the executive to prosecute the Supreme Court, and upon their conviction, overturn all this and other rulings impacted by their criminal behavior on the grounds it violates supremacy. You can impeach them. You can't criminally prosecute them for their decisions. You can impeach them and throw them off the bench if you like. That's an option. And it necessitates the House. Go convince the House. Just go convince the House. You only need half of them, so go get your 270 or something and let me know. This will establish the legal basis for repealing all state laws that infringe upon our right to vote. Technically speaking, you don't have a right to vote. I mean, you might as a matter of state law, but the federal Constitution doesn't say you have a right to vote. It says your right to vote cannot be deprived on certain bases, but it doesn't actually say at any point you have an underlying right to vote. In fact, in the case of the presidency, it very specifically does not say you have a right to vote. It says very specifically, the states shall choose their electors, which they can do through any process they like. They can just do it. They can pass a bill and say, we're voting for X. We don't want the citizens to vote. Screw you. That would be legal. So, no. Additionally, any governor in a death penalty case who allowed the execution of a citizen in their state who was later found to have been deprived of their life without due process of law, is guilty of aiding and abetting first-degree premeditated murder. Every governor is bound by an oath to support the supremacy of the U.S. Constitution, which includes the 14th Amendment's prohibition against depriving a person of life, liberty, or property without due process and equal protection. I'm pretty sure they got due process. This proves Governor Brian Kemp, Ron DeSantis, and Greg Abbott, and many other governors are guilty of multiple counts of first-degree premeditated murder. No. The inability of these governors, among other things, to defeat my argument, they just, again, can't be bothered. From my argument, proves the offending date, they no longer possess the constitutional authority to exercise the sovereign executive powers of the citizens in their state. This fact proves that any bill they signed into law and executive order they issued after the offending date is unconstitutional and must be repealed or rescinded, which includes the signing of legislative and executive orders pertaining to voting right restrictions. What are you talking about? There's a legal argument supported by the Constitution whereby the House and Senate can craft legislation for $6 trillion Build Back Better plan and pass it in both houses and send it to you to sign into law, because this argument makes the votes of U.S. Senators Manchin and Sinema irrelevant. No. Manchin and Sinema have the right to vote any way they want. If they're on the losing side of the argument, it doesn't mean their right to vote didn't matter. It just meant they were on the losing side, which happens sometimes when you take a vote. So their rights are not deprived if they lose by 1 vote, and their rights are not deprived if they lose by 98 votes. They had an equal vote, and they lost. That's not depriving them of their right to vote. If you need any assistance on how to pay for it, all you have to do is ask me. Really? And if your U.S. Attorney General is ignorant of the constitutional laws supporting this argument, all you have to do is ask me. How? How are we gonna pay for the $6 trillion? This is a question I'd like to know on many levels. On the 10th of September 2021, I wrote Charles Retting, Commissioner of the IRS, asking about the status of the audit of Donald Trump. But like so many other officials, he's afraid to respond to my letter. I don't think he legally is allowed to respond to your letter because tax records are kept confidential by the IRS. So what is the status of Donald Trump's tax audit? And why has the United States Attorney General Garland not investigated the 10 instances laid out in the Mueller report whereby Donald Trump may be guilty of obstruction of justice and other high crimes and misdemeanors, and issue a report confirming or denying them? The Attorney General could have done something in response to the Mueller report. There were many problems because most of the issues were things he did in office, which seemed to be within the bounds of his official charge, which made President Trump immune to many of them. And also, on a more important level, the United States House also considered the Mueller report. As you may remember, they impeached him on the basis of the Mueller report. He was not convicted, however. So the relevant body that has the power to determine whether or not he committed high crimes and misdemeanors determined he had not. So I don't know what to tell you more about that. However, there's an argument proving Donald Trump is guilty of tax evasion, and the inability of the U.S. government to defeat my argument invalidates Trump's entire presidency. That is not even remotely true. Which includes nullifying the tenure of every Article 3 judge he nominated was confirmed by the Senate, to include Supreme Court Justices Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. So obtain the final report from the IRS regarding the audit of Donald Trump and give me a copy. No. The U.S. court can't do that for every possible reason. There are reports of you thanking the African-American community for having your back when you needed it most. And with U.S. Representative James Clyburn at the helm, you were voted by the American people to be the 46th president of the United States of America. Unfortunately, when you repeatedly refuse to support my civil rights, and I hear you refuse to assist Black Farmers Association in their case, yet your VP is Black and Cedric Richmond is part of your administration, I'm left wondering why you differentiate between supporting some African Americans and not all African Americans. What? I mean, this doesn't make any sense. When I take note that the similarity between the BFA and myself is we're both fighting for our rights, I wonder if this is the reason. Wow, you've really just made all kinds of logical leaps. You've just made all kinds of logical leaps. Okay, first of all, Biden wouldn't be supporting you in your lawsuit, or them in their lawsuit. That's not how that works. I suppose the Attorney General or the Solicitor General could put in an amicus brief or do it, but they have to make the issues as a matter of law. And hopefully they do. I don't know what the issue with the Black Farmers Association is. I have no clue. But, I'm going to just assume for the sake of argument that, the U.S. government decided not to back them because their case sucked. I don't know. Now, I want you to consider how hypocritical it is for U.S. officials to talk about the rigging of a presidential election in a foreign nation when you have physical evidence in the form of federal court order that a federal judge ruled the success of my claim challenging the constitutional and statutory legitimacy of Bush versus Gore would invalidate the presidency of the United States. Well, it could, which he can't do. I mean, he's simply saying that's basically what you're asking me for, because that's where this road ends, right? You're basically asking me to invalidate the presidency. I can't do that. So he was responding to your stupid. How hypocritical is it for U.S. officials to talk about human rights and abuses in violation of other countries when you have in your possession a federal court order that says a person can be murdered by the government for exercising the First Amendment right to redress? When? How? Who's been murdered? By whom? When? What are you talking about? How hypocritical is it for U.S. officials to talk about their civil rights violations in other countries? Okay, we read that. Then you people have the audacity to talk about American exceptionalism when you deprive the American people of their life, liberty, and process without due process. I feel like they're getting the due process, though. Oh, yeah, Stephanie also, reminds me in chat, because I forgot long ago, that this theoretically has something to do with Prince Andrew. I guess his point is that because the Supreme Court refused to accept his petition because they can't defeat him on the merits, they are implicitly acknowledging that his merits exist. Therefore, all federal courts are illegitimate. Therefore, this federal court is illegitimate. Therefore, they can't prosecute Prince Andrew because he's before prosecute's the wrong word because he's a civil case. They can't litigate against Prince Andrew because this entire federal system is entirely improper. And he wants the court to know about this and that they're an illegitimate court for hearing the lawsuit because the Supreme Court declined certiorari once. I guess that's how it's related. The other day, I was watching a segment on 60 Minutes. Okay. Regarding Intel, and I learned that in 2020, Intel made $78 billion. But instead of taking this revenue and reinvesting it back into their company via research and development and upgrades to their facility, the leadership of Intel chose to line their pockets via stock buybacks. That's not how that works. That's not how that works. They're not lining their pockets. The company is the one doing the buybacks, right? The company is the one doing the buybacks, right? Stock is in ownership in the company. So when you buy a share of stock, you very literally own one share out of whatever of the company. You are a partial owner of the company. Maybe an extremely partial owner, but a partial owner nevertheless. That's what stock is. All right. So Intel sells stock in itself, and people buy the stock and they get money. But it can go the other way around, right? The company can say, you know what? We have all this money on hand, and we have given up too much of our company. We've given up too much of our company in the stock market. So we're going to buy our own stock back and erase that stock from existence once we buy it back, because we can. Once we own it, we can erase it from existence because we paid for it. And now we own more of the company. The company owns more of the company. That doesn't line the pockets of the individual people. That makes the company in greater ownership of itself. That's what a stock buyback is. And it makes total logical sense that Intel would choose to do that with their money. That makes a perfectly valid choice. They could do other things, but that is a choice they can make, which would be logical. And this is at a time when Intel does not possess the level of intelligence necessary. Intel doesn't? To produce the high-speed semiconductors needed by companies like Apple, Amazon, the automotive industry, U.S. military, and Microsoft. In case you hadn't noticed, there were some supply chain disruptions. Then I find out this part of the infrastructure bill includes $50 billion to Intel. When Intel did not work for this $50 billion, nor did they earn $50 billion, they just give it $50 billion of our taxes to do what they should have done with the $78 billion in revenue they generated. This is a microcosm of why the current economic system cannot continue in its present form. I don't know that that's true. I don't know that's true, and I don't know the rationale behind it. Maybe it makes sense. Maybe it doesn't make sense. I have no idea. But, you know, one of the things the federal government can do, for better or worse, is spend money. And they can, if they wish, give money to corporations. Now, I don't think they should do it for corporate welfare reasons, but maybe they were buying something. I don't know. I don't know. I couldn't tell you. Now, because of the chronic stress of worrying about being murdered by the government, because they cannot defeat my arguments, I really don't think the government's after you. I am currently being treated for sleep apnea. Therefore, I'm going to start sending my medical bills to you, since the federal government is responsible for bringing about these medical ailments, and all you have to do is support my medical rights. I'll be able to cover my civil rights, and I'll be able to cover the cost of all my medical bills. But in the meantime, I'll continue to share my thoughts and opinions on matters of law to my creditors and beyond. I'm sure your creditors are thrilled. For the record, IAW 28 U.S.C. 1915 C1, the court may request an attorney to represent any person unable to afford counsel. Let me just Google that real fast and see if that is what it says. Hold on. They might. Let's see what it says. What does it say? 1915. All right, 1915. Okay. No. 28 U.S. Oh, this is 18 U.S.C. No wonder. 28 U.S.C. Okay, proceeding in forum pauperis. Yeah, you can file and okay. It says in section C1, upon the filing of the affidavit and prepayment of filing fees, the court may direct payment by the United States expenses of printing the record, preparing a transcripts, and if such transcript is required, and printing the record on appeal if such printing is required. Such expenses shall be paid. And then it says in E1, the court may request an attorney to represent any person unable to afford counsel. So it's a thing they can do in a civil case. It's a thing they can do. They're unlikely to do it in the vast majority of cases because you don't have a right to an attorney in a civil case. So, but it's something that they can do, I suppose. Yeah. So it's proper to ask. So you got that going on for you. Good one. The petitioner is poor, and there is a legal and public record in the U.S. district courts across the United States attesting to this fact. Yeah, he's been prolific. Due to the demonstrated level of ignorance and contempt of the Constitution and statutory U.S. laws exhibited by attorneys at every stage of their legal career. Okay, what is more plausible? What is more plausible? Many different U.S. district courts, many different U.S. courts of appeal, the U.S. Supreme Court, and many attorneys are all collectively wrong, or you're a moron. I mean, I'm just saying. Have you found any attorney at all to back your play? Doesn't look like it. I reserve the right to choose my own because contrary to what you think you know about the law, every person who goes before a judge or any other tribunal where their rights, privileges, and or immunities are asserted, they're entitled to competent legal counsel. They're not. There is no such right in the Constitution. In a criminal case, yes. In a civil case, no. To ensure their rights as are supported by the supreme law of the United States of America. Also, the U.S. Constitution and U.S. laws made pursuant to the Constitution establishes the final arbiters, interpreters of the Constitution law is not a judge, per Marbury versus Madison. That is exactly opposite to what Marbury versus Madison says. I mean, exactly opposite. I mean, I'll misstate this quote slightly, but one of the most famous quotes from Marbury versus Madison is, "It is emphatically the duty of the courts to say what the law is." It's like, I think it might be chiseled into marble at the U.S. Supreme Court, quite literally. That's Marbury versus Madison. It's emphatically the duty of the courts to say what the law is. I might have misstated that slightly, but not by much. Marbury versus Madison says kind of the exact opposite of that. But the American people, IAW, the sovereign and due process clause. Finally, this is not about innocence or guilt of anyone, but supporting the supremacy of the Constitution. I'm thrilled. Oh, and then there's a footnote. The word may will one day be changed to shall, because this U.S. law in its present form is not made pursuant to the supremacy clause, nor the due process clause. Why not? You people are going to pay me for all this legal education I am and have been providing to you in legal documents over the years. No. Memorandum endorsement. The self-described pro se petitioner seeks dismissal of this case on the theory the Supreme Court and the lower courts of the United States do not support the Constitution as the supreme law of the land, and makes other remarks that need not be summarized. The petitioner is not a party to the case and therefore has no right to seek dismissal or any other relief. Construing his papers as an application to intervene, the application is denied. He's denying himself? Who's talking now? He certainly has alleged nothing that would give him a right to intervene under the rule, nor he has asserted anything that would permit the court, if it were so minded, to permit him to intervene. He's ruling against himself in real time, guys. He's literally ruling against himself. So, that's a thing. Okay. Accordingly, the application is denied in all respects. Petitioner can rest assured the defendant's able counsel are up to the task of advancing any possible meritorious contention they think warranted. No. Oh, no, that's the judge. I apologize. I misspoke. I'm so sorry. Okay, it's signed by the judge. Okay, I'm going to stop having a panic attack now. I'm so sorry. I misread it horribly. That is my bad. This entire last page was the judge writing. Okay. Yeah. Okay. Yeah. So the judge, denied it. So he didn't rule against himself. The judge ruled against him. So, but the judge responded to it. So, okay, that's good times, man. Yeah, no, the actual district judge ruled against him. So that was pretty fun. Thanks, Stephanie, for suggesting this story. That was pretty fun. That was a whole pile of stupid. And it got me to smile, which is very much appreciated. It got me to smile. Because this is just truly ridiculous. To be fair, I've read worse soft sit pro se crazy. So as far as soft sit pro se crazy goes, this might be on the saner side. Because I've read some real shit, man. But, and he actually at times touches on things that are kind of legal arguments. So he has some sprinkles of some thoughts that kind of are legitimate, sort of, kind of, a little bit. So he's got that going for him. But it's a whole pile of stupid. Yeah. This is, yeah. So I hope you enjoyed this stream. For those of you who had not seen it already, a little bit earlier tonight, I posted a video regarding Tasha K and Cardi B and analyzing some articles about Tasha K. Tasha K thinks she's going to appeal all the way to the Supreme Court. I have thoughts. So if you haven't seen that video already, you should check it out. And I hope you find it useful. So, all that good stuff. Don't forget to do the YouTubey things like, comment, and subscribe. And did you know for 99 cents, you too can become an uncivilian? It's true. If you hit the join button or the link that Streamlabs should theoretically be telling you about from time to time, but isn't right now for some reason. If you hit the button, the join button, then you get to join the channel for 99 cents and help to support the channel financially. And that's fun. And as you saw, we have names on screen. So for the uncivilians, there's a reward benefit. So you can get your name on screen. How fun. So all that good stuff. So I'm going to sign off for now. I hope you've enjoyed this. I've been Uncivil Law. Till later, my friends, I hope all's well. Cheers. And goodbye.